management. Some of the starting concepts to appreciate are nothing can save you from yourself. What I mean by that is if you are negligent or have malintent, you will probably get sued. Nothing about structuring will be a bulletproof jacket that will allow you to be silly and to do unreasonable things. So that's sort of a first starting point, but the structure we'll look at acts like a shield in the sense that we hope it will deflect or even stop liability in an ordinary course of business. But if you're off owning a property and you're spraying down the steps of water in the middle of winter or something, somebody slips and hurts themselves, well, you can probably expect to get sued because you were setting up a dangerous situation. So I'm not suggesting that asset protection or risk management is about making yourself invincible so you could act any way you wish. Insurance is another consideration. When we talk about real estate, insurance is very important. In fact, it would normally be a condition of your mortgage that you have it and keep it and don't do anything to breach your insurance, cancel it. Insurance, of course, is limited, and as we've seen, especially in Alberta lately, it doesn't cover everything. Some of the flood damages and things, people are learning quickly that, some of these insurance policies have exculpatory clauses and exemptions and such. The other thing with insurance is a lot of times it's limited in value, or adjuster's job is to try and limit the claims that they have to pay out. So insurance is important, and you shouldn't let anyone tell you otherwise. It's required by the lender for your mortgage, but it's also, just one more layer. So when we talk about asset protection, we want to think of multiple layers to give us more strength. Another principle we deal with is time is your friend. If you're restructuring yourself on the eve of bankruptcy only to avoid debts or to prefer a creditor over another, chances are the court will have a very broad discretion to set that aside. So there are a number of rules in law and in the Tax Act that say if you're just doing something to sort of get out of responsibility or to avoid taxes, then it can be set aside or even be more serious consequences. Similar concept is after the fact planning may worsen the situation. If you've set yourself up in a certain way, you're holding properties and different interests in a particular way, and you've got a problem and you start moving things around to try and get away from liability, it might be seen as a fraudulent preference and could cause liability from the court. Other concepts are you can't get blood from a stone. If you are pursuing someone or someone is pursuing you and they get a judgment, there's a practical reality to that. If you want to decide to sue someone, it's expensive, it's stressful, it's uncertain. It takes a long time to go through a lawsuit of any serious matter. Once you get the lawsuit, if you're successful, you may get some of the costs of it back at the discretion of the court, but you'll get a judgment which is a slip of paper, a legally enforceable debt, but a slip of paper. So if your debtor doesn't have anything to realize against, your paper's not of much value.